You're back, Mr. Frazier?
We
Okay,
are back, Your Honors.
all right, ready to proceed.
Yes, Your Honor. Yes, we are. At the outset, Your Honor, I'd like to reserve 5 minutes for rebuttal.
Sure.
Thank you, Your Honor. May it please the court, my name is Jason Fraser, and I'm here today on behalf of Ms. Nicole Palmatier, who is the appellant in case 2D19-4330. Now, I'm really excited to be here today because we don't often get to decide a case of first impression. I know this is an issue that this court has identified about 12 years ago in an opinion called Chasm v. Linnell, citation 975 Southern 2nd 560, decided by this court in 2012. And the issue is whether a proper award of temporary appellate attorney fees by the trial court must then be perfected by filing a motion with the appellate court under the Rule of Appellate Procedure 9.400 subsection B.
Doesn't say anything that 9600 doesn't say anything like that though, right?
Beg pardon, Your Honor?
9.600 doesn't say anything to that effect, correct?
To what effect, Your Honor?
That it has to be, quote, perfected.
No, Your Honor, correct. It does not contain such a requirement.
Right, and 61.16, the statute doesn't say anything like that either.
That is also correct, Your Honor. So this is an opportunity for us to resolve what's been legal ambiguity for over a decade. So as a brief rundown for the factual history of the case.
Well, apparently though,
okay,
but it's these current, the version of the statute and of 9.600 that exist today have been in existence since the 1994 legislative session and the 1995 change of the rules. So really, if there is an ambiguity, it has existed for about 16 years.
Fair enough, Your Honor.
This is the case of first impression.
It is, Your Honor.
Okay.
Thank you, Your Honor. I appreciate that. Well, to continue with a brief factual summary of the case, this is a dissolution of marriage where a final judgment was granted on December 7th, 2017, and the former husband filed a timely notice of appeal on January 5th, 2018. The former wife, anticipating the need for appellate attorney's fees, being unable to pay her way while the appeal is pending, filed a motion with the trial court for temporary appellate fees under Rule 9.600 sub C. That motion was heard by the trial court on February 13th, 2018, and on the 14th, the trial court granted her motion, finding competent substantial evidence supporting an award of temporary appellate attorney's fees of $9,000, which the former husband did pay to the former wife, and the former wife did use in defending her appeal.
Without a challenge, and that's never been a challenge either by a motion under 9.600.
Correct, Your Honor. It has gone unanswered.
And it wasn't raised in the husband's appeal.
No, Your Honor, it was not.
So never been, as far as we're concerned, that money was necessary for her to have counsel on the appeal.
Correct, Your Honor.
So just to follow up, and the reason I think you're getting questions early on is we've all read this and we know it. We don't want to steal anybody's steam here, but the point is there was a hearing to make findings of an equitable nature of her need and ability to be able to afford to prosecute or defend an appeal. Is that correct?
That is correct, Your Honor.
So that's a hearing in equity where the court makes findings and the court expressed those findings. So that appears to be a standalone rule that allows you to get an award, assuming that you can prove the circumstances, to allow you to entry into the appellate court. Is that correct?
That is correct, Your Honor.
And should the opposing party be challenged that, subsection C provides them with a remedy.
Correct, Your Honor, it does. And that is something that's actually noted in the Chasm case, which I'll get into momentarily.
Right, but the Chasm case, all it does is speculate that there's a question here. It doesn't really say that there is an ambiguity. It doesn't rule on the question. It doesn't really say there's an ambiguity. It says we just don't have to get into it, correct?
Correct, Your Honor, it does.
And let me say, full disclosure, I wrote this part of section 9.600 when I was on the appellate court rules committee, because I was like a divorce appeal lawyer. So I was, none of you have discussed the history of the case law prior to the enactment of the current version of 6116 or 9.600. And I'm very well versed in it. So I know why this rule was done the way it was done.
Correct, Your Honor.
Just to give you a heads up.
Well, thank you, Your Honor. I appreciate that. Well, the first time this became an issue is when the former wife filed a motion for appellate attorney's fees on October 4th, 2018. And she did that in an abundance of caution based on this court's wording in footnote 1, exactly, Your Honor, stating that it might be good practice to follow up an award of temporary fees by securing it by filing a motion in the appellate court. We'd like to give you a quick roadmap of where this case is going to go. And as a threshold issue, we'd like to state that we believe that this is a standard of review de novo. As the court knows, matters of statutory interpretation are reviewed de novo. And because this issue turns on the trial court's, well, it's our perspective that the trial court misinterpreted and misapplied statute 61.16 subsection 1, this is a matter of de novo review. We intend to give legal reasons and public policy reasons why the trial court's order disgorging the award of temporary attorney's fees that were already spent should be reversed. Excuse me. And that is because the Chasm Court drew a distinction both between the definitions of temporary and final fees and the procedures used to obtain those fees. So the Chasm Court explained that up until 1994, any party seeking any kind of appellate attorney's fees was required to file a motion under 61.16 subsection 1 and Rule of Appellate Procedure 9.400 subsection B with the appellate court. However, in 1994, the legislature amended 61.16 subsection 1 and Rule of Appellate Procedure 9.600 subsection C specifically to allow family law litigants to apply for temporary attorney's fees that are reasonably necessary to prosecute or defend pending appeal. And in the Chasm case, the former husband appealed, the former wife filed a motion for temporary relief, but unfortunately the trial court was unable to render an order while the appeal was pending. The order granting her fees came back after the appeal had already concluded. And this court correctly reasoned that, well, if temporary attorney's fees are meant to defend somebody during a pending appeal, those fees serve no purpose once the appeal has concluded. And actually, every instance of the Chasm Court bringing up these fees shows that there is a distinction between both of them. If you actually look at page 563, at the top of section 2, the court explains that in domestic relations case, temporary fees to prosecute or defend an appeal or final fees at the conclusion of an appeal. The use of the word "or" in this sentence draws a clear distinction between the two of them. They are two separate issues. And as the court noted it by quoting Rosen, this is to ensure that spouses have similar abilities to retain competent legal counsel. The language also supports that two procedures are used. Further on in 563, the court mentions that the wife in that case couldn't rely on 6116 sub 1 and Rule 9.600C because the appeal had already concluded. At the conclusion of the appeal, Rule 9.400B is the proper vehicle for seeking final attorney's fees. The language is further supported on 565 quite plainly by saying, because the wife did not obtain either a timely award of temporary attorney's fees in the trial court or filed a motion with the appellate court, her award could not be affirmed. If the court respectfully had intended to impose a requirement that a movement file to perfect an award, it would not have said "or." The word "and" would have been used. In fact, nowhere in the opinion, as Your Honor stated, nowhere in the opinion does the court use the term "perfect the award." They just say,
as I said, the court expressly did not address the issue that has been presented by the judge's ruling in this case.
Correct, Your Honor, but they did. Go ahead, I apologize.
So I really don't see how chasm is helpful to us at all, frankly, other than that Judge Altenburn decided to put that footnote in his opinion.
Yes, Your Honor.
Suggest a best practice. And in your situation, you represented, and you did in your motion that this court struck, that you didn't really need another award of fees, that the temporary award was plenty, and that you were only filing it because of that footnote, correct?
Correct, Your Honor. That is 100% correct.
Now, in the order that is on appeal, the judge wrote, where is it? He cites Rule 9.600. He cites Rule 9.400 of Rule of Appellate Procedure, and then says statutes awarding attorney's fees must be strictly construed, and it cites a number of cases, for that proposition. But 9.400 is not a statute awarding attorney's fees, is it?
No, Your Honor, it's just the procedural.
And neither is 9.600, correct?
No, Your Honor, they're procedural.
Right. And they're court rules, they're not statutes.
Correct.
And there's no law that says we have to construe court rules strictly.
There isn't, Your Honor.
Okay.
Well, Your Honor, if we're going based off of the order that's being appealed, it seems though the trial court's opinion was mainly based on the Rados case, Rados v. Rados, citation 791 Southern 2nd, 1130, decided by this court in 2001, where the court stated that a litigant who wants to pursue a claim for appellate attorney's fees is required to file a motion with the appellate court pursuant to Rule 9.400 sub B. However, that is a misapplication of the law, because in the Rados court, the appeal took place, the motion for fees took place after the appeal had already been concluded, which is exactly the conclusion that the court supported in Chasm. We are in a different factual scenario. Here, the trial court timely and properly awarded temporary appellate attorney's fees before the appeal had concluded. And we've got other cases that support that contention. In fact, let me see here. And Your Honor, just to bring back briefly, the court gives us instructions in Marion v. Merhige, I'm probably pronouncing that incorrectly, citation 690 Southern 2nd, 678, decided by our sister district in the 3rd district in 1997. In that court, they stated that if the party if the trial court enters an order and the losing party, in this case, the former husband, desires appellate review, the losing party seeks review by filing a motion pursuant to Rule 9.600C. And under Rule 9.600C3, the deadline for filing such a motion is within 30 days of rendition of the order. The former husband's motion addressing the trial court's order of temporary fees was filed 377 days after the rendition of the order and is untimely by a plain reading of Rule 9.600C3. The 3rd district gives us further instruction in Swartz v. Swartz, 691 Southern 2nd, 2, decided in 1996. That's an interesting case where the appellee wife filed her motion for appellate fees with the appellate court as she thought was required, but the District Court of Appeals actually rejected it and told her to file in the trial court. It did not mention anything about her needing to perfect anything once she filed in the trial court. There's no legal requirement that anybody perfect something in the trial court. And as we'll see in just a moment, it actually goes against public policy reasons as well. Excuse me, Your Honors.
Mr. Fraser, you're coming up on 5. You're about down to 5 minutes. So if you use them as you wish, but that would be your rebuttal time. So
then I'll conclude briefly with the public policy reasons, Your Honor. The 1994 amendments were expressly amended to avoid inequitable inequity between the parties pending appeal. The former wife correctly filed her appeal under 9.600C and 6116 subsection 1. If this were a case where she received fees and didn't spend them all, then sure, we can understand returning them, but that's not the case here. If the former wife can't afford counsel up front and needs those temporary attorney's fees, it strains credulity to think that she'd have the ability to pay these fees back after they've already been spent. We're worried about a chilling effect on litigants. Somebody who has a reasonable defense or prosecution on appeal may not want to file for temporary fees because they fear having those fees ordered returned and going into debt because of it. If they're going into debt because of these fees, they're risking orders for contempt, they're risking incarceration. It's going to cause a mess. By the same token, attorneys are going to be less likely to take these kinds of cases if they can't guarantee that the payment they receive to prosecute or defend appeals is going to remain in their pockets. Why would they want to take that case? And this would also be the only situation that I've ever encountered where the prevailing party has to file something to secure their fees. The purpose of an appeal is to correct or to address an aggrieved party's concerns. If we reverse that by requiring the prevailing party to file, it defeats the purpose of an appeal. We wouldn't be able to be sure of trial court awards and would have to, as a protective measure, file appeals on almost every issue. And because of that, Your Honor, we think public policy and the legal interpretations, as the court stated, requires that this court reverse the disgorging of the order. And with that, I yield the time to Mr. Butler.
You got about 3.5 minutes left for your rebuttal.
Thank you, Your Honor. I appreciate that.
Okay, Ms. Butler, you're up. And you are muted. Everybody does that.
Third time. And I said to myself, don't forget to unmute. Your Honor,
you don't get points off.
Thank you. Thank you. Tony Butler, I'm here for the former husband, Scott Palmatier, as the appellee this afternoon. May it please the court. Your Honor, our position is that the difference here is that 6116 and 9.600 authorize a trial court to award a temporary order of attorney's fees. The case law has always been, and I think still is, that the final award for appellate attorney's fees lies within the purview of the appellate court. 6116, the amendments in 1994 to 6116 and 9.600 did not discharge the obligation of a party under 9.400 to file a motion for appellate fees in the appellate court.
Well, under 9.600, which court under 9.600 has only the authority to award fees? Which court?
Under 9.600, it is the trial court.
Exactly.
Temporary.
Which court under 9.400 only has the authority to award fees?
The appellate court.
So what you did in this case, and the trial judge basically made it clear, you didn't argue equity in your motion to disgorge. You would agree with me that under 9.600, the former wife properly filed a motion, had a hearing, produced evidence, and demonstrated a need and ability for appellate fees, correct? And your client never challenged that.
I would agree, Your Honor.
She never moved for appellate fees, which can only be awarded by the appellate court.
That is correct.
So we had a hearing based on equity with findings. Judge Cupp here has ripped away her fees without a finding of a need and ability to pay. The fees that were awarded by Judge Quire that she proved to allow her to walk in and open the door of the appellate court, not to prevail. And your argument below to Judge Cupp was she didn't prevail on appeal, therefore I'm entitled.
No, Your Honor, not that she didn't.
Under what grounds are you entitled to appellate fees under 9.400B?
Under
No,
9.
what I think the judge said and what Ms. Butler was about to say is he didn't say you didn't prevail on appeal. He said you didn't obtain a fee award from the appellate court, and therefore you have to give the temporary fee award back.
Well, but the
Right.
first argument made by husband's
Right.
counsel was the wife didn't prevail. So he's
mean
going
that-
under,
Do you mean
and
at the
he
hearing?
did.
Do you mean at the hearing, Your Honor, in the
No,
trial
on appeal,
court?
on
On
appeal.
appeal?
Yeah.
I don't know that that was an argument that was meant to be substantive. He did.
Well, and then the
prevail on
husband
first
argued,
appeal.
then the husband said this, and I quote,
Mhm.
my argument is procedural and jurisdictional. So he's using a procedural and jurisdictional argument
Mhm.
to disgorge fees that were awarded based in equity under a totally different rule that makes no reference, express or implied, to 9-400.
And that's exactly my point, Your Honor. It did not obviate the necessity for an award of.
But there's no, let me tell you, I can give you the background on these rule changes. Okay, back to the early 20th century, Florida appellate courts were allowed to award, were empowered to award temporary appellate attorney's fees in family law cases. There was no statute that said that, actually. It said this is part of our court's equitable authority. Flash forward into the time when I was practicing, which wasn't in the early 20th century, but I would say maybe a little mid-century and later. I would file a motion in the appellate court for temporary fees, and the appellate court would remand to the trial court and relinquish to the trial court to decide that motion. That's what was happening left and right. The trial court then was exercising the appellate court's authority pursuant to the relinquishment order. That's conceptually how it worked. In 1994, I was on the appellate court rules committee, and because I was a family guy, I was the family law subcommittee. And we proposed to the Supreme Court amendment to 9.600 to authorize the trial court to have continued jurisdiction. And we proposed to the legislature that they amend 6116 to specifically insert appeals in that sentence. It says the trial court, will award from time to time make these awards as necessary. And the sentence, I don't think the legislature needed to do this, and the sentence that said, and you'll have continuing jurisdiction. But from that point forward, and again, there's no case law on this, as you point out, this is a case of first impression. But the assumption was that from that point forward, the trial court would be exercising its own authority to award temporary appellate fees where one of the parties needed it. And there was no need to go to the appellate court because it wasn't the appellate court's authority that was being exercised. But in this concept that the trial judge seems to have applied is that really, it was the appellate court's authority, and it didn't really kick in until the appellate court made an award under 9.400. But I think that conflicts with the history that preceded this.
It may conflict with the history, Your Honor, but in both 6116, the amendment, and the amendment to 9600, both were amended to state temporary appellate fees.
It's temporary. But temporary, interim. I've seen an opinion by Judge Cope about interim. It's all interchangeable words. That's what temporary child support. Do you have to give the temporary child support back if like one of the children ages out and you don't get a child support award at the end of the case? I don't think temporary means it's not real, and you have to give it back.
And our position is that the rules are not read in a vacuum. They're always read together.
Indeed.
To make sense of each other.
Then read for me 9600C3. You tell me what that means.
Okay.
Review of orders entered pursuant to this subdivision, temporary fees for appeal, shall be by motion filed in the court within 30 days of rendition.
Yes.
What does it mean?
It means that if the party disagrees with the award of appellate temporary fees by the trial court, a motion must be brought before the appellate court within 30 days.
Does that make any reference to 9400 giving you entitlement to disgorge these?
It doesn't, but then again, it's an award of, and Judge Northcutt, I apologize if I'm not getting the historical intent
Well,
correct.
you
It's an
know,
award
because
of
I
temporary-
think the arguments would have benefited from that, and maybe
Right.
the Judge Cup would have benefited. But here's the thing,
Mhm.
you know, and you're hanging your hat on the word temporary, but that's not the same thing as conditional, right? That's,
No,
you know,
correct.
it is an award of fees. It was a temporary award. There may be, you know, there may be more necessary down the road, and the trial court could award more while the appeal was pending, and then when at the end of the appeal, the appellate court can award more. There's nothing that says it's temporary in the sense that it's conditioned on you getting an award at the end of the case under 9400.
Well, let me ask you this. Let's assume that the former wife was the prevailing party. She did timely file a motion under 9400B. And we as a court awarded her entitlement, remanded to the trial court. What the trial court could do is do a set off of the temporary fees that were awarded, and the husband would only have to pay the difference. Correct?
That would be correct.
Okay. So how, let's flip this. Just because of procedural mistake, what really isn't a mistake, because she never sought appellate fees. Fees that are awarded at
any more beyond the temporary award.
she never sought appellate fees upon the conclusion of the case, of the appeal, which is based on statute or contract, whatever.
Mhm.
Under 61. She didn't ask for them. She never did. She didn't need to, because she got them below.
Right.
And those are expended to get her into court, but yet you're saying they're temporary, which means you can just go back and take them away no matter what without a hearing. There was no hearing in this case. Judge Cupp said, pay the $9 grand. I don't care whether you can afford it or not.
The rules matter, Your Honor, Judge Sleet. The
So
rules,
form over substance.
and I understand your argument under equity because he didn't appeal the need and ability to pay the order that when it was originally entered. He is proceeding based solely on the fact that she did not file and request well, she did,
Well,
but she
let
not
me ask
timely
let me
filed.
ask you a question in terms of, you know, 9.400A,
Mhm.
which addresses costs.
Right.
The cost shall be taxed in favor of the prevailing party. But that's not how family law works, correct?
No, it's not.
Okay.
Not typically, no, Your Honor.
That never, correct?
Correct.
Okay.
It's equity.
So there is a provision in the rules that contemplates your typical civil dispute, not family law.
Right.
All right.
Right. And I agree.
Ms.
Family
Butler,
laws, but and I think that
And
nine
the rule here that specifies family law is 9.600.
correct. It breaks out a section that is specifically geared to a family law proceeding.
Ms. Butler, I'm somewhat hesitant to jump into the phrase since my colleagues have asked you a lot of questions, but I have a couple of questions relating to the impact of the order, where it requires the attorney to disgorge the $9,000 in fees. Now, if the wife has no ability to pay fees and she has a need for fees, is this a sanction against the lawyer for not requesting fees on appeal, or is it essentially requiring pro bono services be rendered by a lawyer to a person who has a need and no ability to pay fees otherwise?
Well, with all respect to Mr. Peterson, who was trial counsel, if he's going to handle an appeal, he should know the rules of appellate procedure. And to me, 9.400 is clear. 9.600 and 6116 are clearly
But so
temporary
ultimately-
awards, which this court doesn't.
Ultimately, then, your argument relies on conflating the two rules, correct?
I wouldn't call it conflating the two rules. I think you have to read them in tandem.
What you're saying
And-
is the
and-
word temporary,
and
the word
temporary-
temporary as used
I think temporary
means-
makes a big difference. I do.
makes it conditional. Makes it
If-
not,
if-
makes it
if you-
conditional.
If you will, because the case law cited in
So
the
like if you got a temporary support award
Mhm.
but you didn't ultimately get a support award because of
Mhm.
maybe the equitable distribution, you got to give the temporary support back.
That's at the discretion of the trial court. A lot
I
of
would
times,
submit-
I mean,
Yeah, okay.
there may be a smaller award and overpayments will be credited
So did the
against.
judge here exercise discretion, or did the judge say, oh, you have to construe this rule of court strictly, and therefore the money has to be disgorged?
The trial court construed the rules as they are written. Temporary, the case law that says that the appellate court has the ultimate authority to award fees. Even
What
rate
if
of,
he was reading the cost part of 9.400? Would he say, well, you know, who won here? Who was the prevailing party?
well, it doesn't matter in this case because it
In
doesn't.
this
apply in
case, but the principle matters. You're suggesting that the costs always have to be awarded to the prevailing party, even in a family law case.
No, that's not what.
That's what 9.400 says.
9.400 in a different subsection, I believe, says that, Your Honor.
Well, 9.400, yeah,
but-
because
but-
the cost
but
as
flip
opposed
it-
to fees.
Flip it around to the point that I made toward I think the end of the brief is, and Judge Sleet may already have touched on this, but basically you're saying that even though the rule and the statute both refer to an award of temporary appellate fees, they should be construed to be final so that there is no oversight by this court. It doesn't, this case is different.
Actually, what
because
we're
she didn't-
saying, what I'm saying is that
Mhm.
you shouldn't treat the word temporary as meaning conditional. And there is oversight in sub, whatever it is, 3 of 9.600 C. And a final award can be interpreted as the amount of fees necessary to make this person whole after deducting the temporary fee award. The temporary fee award is
And we come back to
Pending
footnote
the
1 in
case.
CHASM, which is really the groundwork for this appeal. That
and it
footnote-
doesn't answer the question.
And
It poses a question
it
and it
poses-
doesn't answer it, and it gives no basis for deciding this question.
Right, but it also treats it as a temporary award. And the case law that's
Yeah,
cited
but
in my
that's a
brief, the temporary-
footnote that is a footnote that is gratuitous dictum for best practices, because the holding of chasm is this. Because the wife did not obtain either a timely award of temporary fees in the trial court or, not and,
Mhm.
you're trying to
While
create
the
a tandem,
appeal
you're
is
trying to create a tandem bicycle. See, the trial court gave me my bicycle. The appellate court awards you a different bicycle. You don't put those two together. It says, or file a motion in this court seeking fees in the first appeal, the trial court's order is reversed. These are two different animals according to this court in chasm.
But look at the facts in CHASM, Judge Sleet.
Yes, she filed a motion for temporary fees after a appeal was concluded.
And the trial court did not.
And you
have
cannot
jurisdiction.
argue here that this was not a timely motion for temporary fees because you never challenged that.
I'm not arguing that, but in the
And you've
fact,
never challenged the fact that she was found to be entitled to that in the trial court.
I'm not in the habit of bringing meritless
And so
appeals.
based
Your Honor.
on
I'm
just-
attempting not to.
Based on failure to file a timely motion in a different court, your client's entitled to remove $9,000 from the wife without any hearing whatsoever.
Well, there was a hearing. I think Judge Cupp recognized Judge Creer's order, finding need and ability to pay and an equity granting her the $9,000. But I believe, like the rest of us, and looking at footnote 1 in CHASM, they made a distinction.
I think it's pretty
between the
clear that
two.
we don't give any weight to
I-
that footnote whatsoever. So please stick to something else because we are
I-
not
I
writing a brand new opinion based on a footnote.
Well, especially since that footnote begins with these four words, we need not address.
Right.
I mean, so it
Right.
didn't address.
Which
Right.
usually means
Just
we need
raised
not
an issue.
write this.
Right. It just raised an issue. And I believe that where we are coming from hinges, as Judge Northcutt noted, on the word temporary and the distinguishment in the case law that temporary awards can always be vacated or modified as long as the litigation is pending,
Well,
because
you know
they're not
what,
permanent.
you might treat it that way, but that wasn't the basis for this ruling. This ruling said you have to treat 9.400 as the basis for the award, and it has to be construed strictly, and therefore you have to give the money back. It didn't say, you know, I'm exercising my jurisdiction to say, my discretion to say, you know, even if this was the state of the law, I'm not sure it is, having gone past the review period and done nothing. But when the judge says, you know, if he said, I'm exercising my discretion because it turns out you don't need it anyway, that might be an argument. But the fact that it's temporary in that sense doesn't mean it is conditional on the person having to do something else in another whole nother court down the road.
And if I may just point out one of the cases, Your Honor, cited in my brief, that would be the respiratory care services case. And 1 second, and I will give you the site on that.
Okay.
While I'm looking that up, the purpose of me pointing it out to you is because in that case, it was, if I'm not mistaken, a malpractice case. And under the statute that applied in that particular case, the award of attorney's fees was mandatory. The attorney in the appellate action did not file a motion for attorney's fees pursuant to Rule 9.400. And that court held, and that is Respiratory Care Services versus Shear, 715 Southern 2nd, 1054. It is out of the 5th District in 1998.
Yeah, but we've helped you use your time and we're beyond it. But I will point out that that's not a family law case. That doesn't involve 6116 or 9.600.
It involves 9.400. And
Right.
they ruled that even if the award under the statute is mandatory, the appellees were still required to file a motion in the appellate court.
But unlike in family law court, that case does not involve the principle of making certain that a party can open the door to the appellate
The
court.
equitable argument, I understand.
And to tell you, you have characterized that as saying that this procedural jurisdiction defect is jurisdictional, but the court says that in order to invoke our jurisdiction, you need to file a motion under 9.400. It doesn't say if you file it untimely, we don't have jurisdiction to consider it.
Correct.
So in any event, we have helped you use your 20 minutes, and I know they were a difficult 20 minutes.
Oh.
And you have comported yourself quite well under fire.
Yes, you have.
I appreciate it, Your Honors. Thank you very much. Obviously, I'm here requesting that the court affirm the trial court's order and perhaps ask the legislature to amend the language of 6116 and 9.600 to say, if you do this, you don't have to follow any other rules.
Okay,
Thank you, Your Honors.
thank you. All right, Mr. Fraser, I think I left you with about 3.5 minutes.
You did,
Your
Your
Honor.
Honor. Thank you. And I believe this will be brief because the panel has respectfully addressed most of my concerns. As Your Honor pointed out, the respiratory case is not a family law case and not subject to 6116 or Rule 9.600. But similar to the panel, my concern is the implication that temporary should mean conditional when no such rule exists. Opposing counsel has made it clear that her concern is that a temporary award is subject to modification and oversight from the appellate court. But respectfully, that is possible under the current structure. A motion filed under 6116 and Rule 9.600 subsection C can be reviewed by the appellate court, assuming that the opposing party files a proper motion under Rule 9.600 sub C sub 3 within 30 days. That was not done here. Accordingly, since there has been no challenge to the award of temporary attorney's fees, since the attorney's fees have been spent, since there's been no hearing referring to Ms. Palmetier's ability to pay and return those $9,000 fees, we would ask this court overturn the trial court's ruling and return the $9,000 to Ms. Palmetier, subject to further proceedings by either court.
Okay. Thank you both very much.
Thank you very much, Your Honors.
That's the end of our docket. As you leave, press the button leave in the lower right corner of your Zoom window, and that will take you out of our virtual courtroom.